Hello, my name is Taylor Willingham with the Willingham Law Firm, and I've created this video for all of you who may have a son or daughter who's getting expelled from school. So what are your rights? What can you do? How can you protect yourself? I want to make a disclaimer, this video isn't all-encompassing of all your rights. You probably should see an attorney to explore all your rights in your state. And this is, I'm a Texas attorney, I only know Texas law, so I can't advise you necessarily on your state. But let me give you a little idea. This video is just meant to give you a general idea of what's going to happen. So there's a little process that schools are required to follow. Most likely they have to notify you through a letter or something that your child has been suspended. They can't just expel your student or your son or daughter. They have to give you some kind of notice that they're going to hold an impartial hearing. That's what they're going to call it. In all respects, it's not going to be impartial. It's very one-sided. You're not afforded pretty much any rights when you go to it, but we'll talk about that in just a minute. So you're going to go to this hearing. Most likely the principal is going to be the one that decides. Some disciplinary councilman is going to accuse your son or daughter of violating what's called their student code. That is the document that's going to govern whether or not the student can be expelled. It's not necessarily a statute or a law that they're going to use. They're going to use their student code. And you're going to have to go through that and see whether or not in your determination your son, well, in all reality, they don't care if your son or daughter actually really broke something. They're just going to make a determination of whether or not they should be in school. Expelling has gotten out of control in this country. We do it because schools have developed this policy of zero tolerance. We're not going to tolerate anything because we don't want to lose our jobs. And if your son or daughter ever did anything and it was known before, everybody's going to be up in arms and have you or have them fired. So schools have gone completely to the other side, and if your son or daughter does anything close to the boundary, they're just going to expel them to save themselves. This has caused a serious problem in our country because multiple good, honest kids are getting expelled when they really haven't done anything wrong. Let me give you an example what could happen in the process that you're going through. Okay, so your son or daughter has been suspended because they made a threat. They threatened someone at school. They woke up that morning, went down to school, got all mad, and someone picked on them, and so they said, I'm going to kill you. I got a gun out of my car. And immediately that person runs to the principal and tells him that you said you have a gun in your car, or your son and daughter has a gun in their car, and they're going to shoot him. So the principal has a councilman go down, picks him up, interviews your son or daughter, and interviews the person. The person's terrified, claiming all kinds of things, and then your son is suspended. The next step is they have to hold a hearing if they're going to expel your son or daughter. And so, at least in the state of Texas, they have to do that within 3 days. It has to be some kind of short amount of time. And then they need to hold this hearing. This hearing, your son or daughter should be afforded due process rights. What that means is due process rights are things that are fundamental to this country that we say everyone should have a right to do it. The Supreme Court has said that in school hearings, because the government is taking away a right that your son or daughter has to go to school, they're taking that away. They have to offer them due process rights, which usually means they need to have a hearing in front of an impartial judge. They need to have a right to represent themselves, and they need to know the charges that are being brought against them. It's my experience when you go to these hearings, they do not afford you even close to the due process rights that they should. Usually the impartial person is going to be the principal, who's heavily engaged in the matter already. The person accusing, or that's going to be recommending expulsion, is going to be the other councilman who he's good buddies with. So I think that's a conflict of interest right there immediately, but that's how it's going to be. Then you're going to run into the problem of there's going to be all kind of hearsay violations, which hearsay means that the person that is making the allegations won't be making them directly in front of your child, someone else will say, well, I heard so-and-so say this. So your child won't even have the right to be confronted by whoever's accusing them. We do this, or they say they do this for the reason of protecting the student who makes allegations, which very might well be so. There might be some situations where a student needs to be protected, but the hard part is when you're in the hearing, you won't know what really happened. You'll have a councilman that's telling you what happened and what he overheard happened. That's going to be very troublesome. And then the last thing is they're going to offer you a right to bring your reasons why your student should be expelled. Because there's a zero tolerance policy, they're most likely just going to be expelled because that's the easiest way to save the principal from anything that could happen down the road. If you really look at the principal's perspective, he's going to look at this and go, you know what, if I don't expel him and he does something, I'm going to lose my job. And if I expel him and then I know nothing's going to happen because he's not going to be here, then I'm okay. So I'm just going to expel him and make it easy on myself and on the school. So what are your options? What can you do? Well, you can. I'd encourage you to go see an attorney. An attorney can try to make a legal argument at the first hearing with the principal. My experience has been the principal probably doesn't understand anything what the attorney's talking about. The attorney will try to bring up some legal arguments, but the principal is going to be all confused because he doesn't understand the law, and the attorney's going to try to get the child off that way. The problem the attorney's going to have is the attorney can't dispute the facts because the kids or the people there that he could dispute them against are not going to show up. So you're going to have written statements against your child, and you can't cross-examine a written statement. And so your attorney's going to have a lot of problems in representing you. So the best chance he has is to make some kind of legal argument why they're doing things wrong. The principal's probably not going to listen, but it might scare the principal enough to go, hey, these guys have hired an attorney. You know, I don't want to end up in court. This seems kind of a ridiculous argument that we're making against this kid, so let's just not worry about it. Most likely they're going to expel your child. So what's your option after that? They're going to tell you can appeal it to the board. What that means is most cases is the board is going to say, oh, well, they're going to record the initial hearing, and the board says, well, we'll listen to the initial hearing and then we'll make our determination after that. And so your child won't even get to go to that. Once again, I think that's a huge violation of your kid's procedural due process rights, but that's up to the school to make. That's the determination that they can have. Now, your last option is if, let's say, the board agrees and they expel your kid, and you're worried because your son or daughter is a perfect student, never done anything wrong, never made any kind of peep, never had any disciplinary issues before, and now this is going on his record. And he's going to have to report this on when he applies to college that he was expelled, and you don't want that. Well, this is where your attorney can really step in. He can appeal the decision to the district court. And the district court can hear whether or not, in their opinion, the rights of your child were violated. This is where you can really get an impartial third party to listen in. Of course, this is going to be a lot more expensive, but when you're at this level, the judge can determine whether or not procedural due process rights were met, which your attorney can make some arguments there, and then also whether or not your child really did something that violated the student code that they put forward. And if you win that case, then your son or daughter will have full rights to go back to school without any prejudice against them. If you lose the case, then the worst thing that happens is your son is still expelled. So son or daughter is still expelled from school. So you do have some rights. You don't just have to accept what the school says that this is the finality of it. Really going to destroy his or her life? I don't know. If you look at it, and he's going to Harvard University, he has the grades to get there, he has the brains to get there, and on an application it's between him and another kid with the equal and same value, but the other kid wasn't expelled, yeah, then this definitely is going to affect his life. The odds are is your kid's probably not going to Harvard. He's probably just going to regular school, a regular college, and he's going to do just fine. They'll probably look at the expulsion, and you can show afterwards that your child had no problems, and it really looks like he's a good, decent kid. It was just an isolated incident, and you have an opportunity to explain the situation. So you don't necessarily have to appeal it to a district court, but know that you do have a right. You do have a right to get it out of the school district and go to the court system and have them decide it. Many cases have gone in front of the Supreme Court that involve expelling a student from school because the people who are making the decisions at the school level are not attorneys. They don't know the law. They don't understand it. And so they make errors. They make a lot of errors. And they're just officials, and they're trying to do their best. Now, like in all things, keep a level head. Understand. Don't take necessarily personal what the principal and everybody's trying to say. They don't know what really happened. They're just accusing your son of something because they have their job to protect. They have themselves to protect. Some of the things they say, I know, are harsh and hard to hear, that they accuse your kids of certain things that might totally just not be true. But you just got to be a little bit understanding of their situation, but understand that you do have rights. You can protect your student from these situations. So if you have this kind of problem, please go see an attorney. Ask them. Go through it with them. Go through the reality of anything, and then determine whether or not it's worth actually bringing a case to the district court. Let some time pass and some understanding come in that this is going to be an expensive process. You're not going to get your money back, your attorney fees back most likely, unless it's egregious in some way. And so if you have any questions, please go see an attorney. And this is Taylor Willingham, and thank you for listening. Okay, bye.